Hi, I'm Jason Sullivan of Rathbone Group, and this is on subrogation. In this video, we're going to look at out-of-state collision coverage and what that means to a consumer and to you as a subrogation professional pursuing your claim. So let's say you are traveling across the country. You live in a state where you have to have a minimum of $10,000 in property damage liability coverage on your auto policy. You are driving through another state where the state minimum limit is $25,000. You unfortunately get into a collision. It's your fault. You caused the collision, and now you have damages that are being claimed against you. Your insurance company is going to have a $10,000 policy limit, but the loss happened in a state where, let's say, it's a $25,000 policy limit requirement. What happens if you have a claim against you for $20,000? Is your insurance company only going to pay the $10,000, or will they pay more because it happened in a state with a higher state minimum requirement? As a consumer, that is a great question for you. You're going to want to know, are you on the hook for these additional damages? Is your insurance carrier going to protect you? As a subrogation professional, you're going to want to know, am I pursuing someone who has an underinsured issue? They don't have sufficient limits to cover all of the damages in the claim. So let's look at two examples that I have had in the recent years that involve this situation. First situation was a loss that happened in Arizona. And it's important to know at the time of this video, Arizona has $15,000 in state minimum PD liability on auto policies. Now, there was a collision with my client's insured in Arizona, but the driver was from California. And at the time of the collision, California only required $5,000 in state minimum PD limits. My client's claim wasn't particularly big, but it was more than $5,000. We reached out to the other carrier. They agreed, clear liability, no question the California driver was at fault, and then they sent over an offer for $5,000. And you may be asking the exact same question I'm asking. Why in the world are you lowballing this clear liability claim? The claim was under $15,000. The loss was in Arizona. So just offer the full amount of the claim. Let's close this one and move on. But they wouldn't. So they wouldn't give any other information other than here's our offer of $5,000. A lawsuit was filed, and then according to the rules in Arizona, there are initial disclosures, and the other carrier provided their copy of their insurance policy. And the first thing I looked for was, is there an out-of-state coverage provision? Now, we just call those step-up provisions because generally what those out-of-state provisions say is the insurance carrier is going to pay their liability coverage either for the amount stated on the deck page, or they're going to pay up to the state minimum required in whatever state it happens in, if it happens in a state other than where the insured vehicle is garaged. So the insurance company is willing to step up the liability coverage to make sure that the insurance coverage matches the minimum requirements, or more if they've already paid for more liability coverage on that policy. So I looked at this and I saw there was no step up in coverage, and they only had the $5,000 to offer under their policy. Now that's bad news for the California driver because their liability is not limited to just the $5,000. But now my client had a decision to make. Are they going to continue to pursue in litigation to go after that underinsured motorist for the amount over $5,000? Or would they just accept the $5,000 because that was all the other insurance carrier was obligated to provide and pay on behalf of their insured? So now let's look at another situation I had. In West Virginia, there was a loss, and in West Virginia, the state minimum PD limits are $25,000. But this time it was a New Jersey driver who happened to be in West Virginia, clearly caused the loss, no dispute on liability. But in New Jersey, he only had to have, like in California, the $5,000 minimum PD limits. Now on this claim, my client got the $5,000 offer and they said, no way, our claim is under $25,000, but it's a lot more than $5,000. We're going to pursue this. We want the full amount. So we reached out to the other adjuster and they said, nope, we're not required to pay anything more. And I suspected that they had that out-of-state coverage or the step-up provision in their policy, but the adjuster just refused. So we filed suit. And in this case, we had an attorney who was also an employee of that liability carrier as the defense counsel on the matter. And again, they refused. Nope, we're not paying anything more than the $5,000, and they wouldn't turn over the policy. Well, I pointed out to that attorney, maybe you have a conflict of interest because you are an employee of the company and you have the ability to pay to resolve this for your insured, but you're actually representing the insured who just wants this to go away, so you might have a conflict of interest there. And if you would like more information on conflicts of interest that might come up in subrogation cases, check out our video on that topic. But back to this scenario, that attorney agreed. He did have a conflict of interest. So what did they do? They got it to outside counsel, who we eventually, through discovery, got a copy of their policy. And sure enough, guess what? It had the out-of-state coverage where it said, we are going to step up and pay up to the state minimum limits required in the state if it's more than what we have on this policy. And sure enough, that's what happened. Unfortunately, that defense attorney couldn't get his client to offer the full amount of the claim, even though it was clear liability. Now, this was during the height of the COVID pandemic and court systems were pretty slow. So once we had that policy in place, what did we do? Well, we turned around, we stayed our case, and we filed in arbitration forums. And it hadn't been filed there before because the other side was raising their policy limits as a defense, stating that that wouldn't be subject to the jurisdiction of arbitration forums. But once we had in hand the statute that says West Virginia state minimum PD liability on auto policies is $25,000, and we had the other carrier's policy that said we are gonna pay up to the state minimum if the loss happens in a state other than New Jersey, we filed that with arbitration, and the arbitrator got it right. They looked at it and they said, yep, you have to pay the $25,000. Your policy provides up to that coverage because the loss was in West Virginia, and therefore there's no out of jurisdiction question. You have sufficient limits. Your insured's clearly liable, so please pay this claim. So we won that claim, and so success for us, yeah. But the thing to look for whenever you're handling these cases where you have a tortfeasor who might reside or have their policy or vehicle garaged in another state is, what are the different policy limits that are in play? So you want to always confirm the policy limits where the loss occurred and not just what the other carrier is saying. Because if they have that out-of-state coverage provision, they're going to be obligated to pay more. If the other carrier claims that they owe less because of the state limits where that policy was written for their tortfeasor vehicle, you're going to want to get a copy of that policy because more often than not, people do pay for insurance coverage that protects them as they drive all across the country. They don't want to have a low limit case that's good enough in the state where they are and then have this extra exposure when they drive into other states. So a lot of policies have this out-of-state coverage or the step-up provision. And if a carrier is claiming, no, we're just going to pay our state limits in the garage state, well, you want to look at that policy and get that from them. And that may require litigation. Finally, remember that even if the other carrier insists and they're correct that they only owe to the state limits on that policy where the vehicle was garaged, that doesn't mean that the tortfeasor is immune from additional liability. So, as in the Arizona case that I had, we could continue to pursue that California resident for the amount over the policy. That's just pursuing an underinsured motorist. There's no immunity for them because they have that state minimum in another state. But as a client, you have to consider all the aspects of pursuing that underinsured motorist. So if you want more information on pursuing underinsured motorists, check out our video on that topic as we provide some helpful information on making decisions on whether it's worthwhile and you're likely to see an economic benefit from pursuing that claim. So for On Subrogation, I'm Jason Sullivan, and that's the long and short of it.